Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court taken into custody.
Really?
1. This hearing is nothing short of mayhem from beginning to end. Mr. McLeod is facing a serious charge, assaulting a police officer. Instead of addressing the accusation, he launches into the classic sovereign citizen routine, insisting the court has no jurisdiction over him. He interrupts, raises his voice, and throws around pseudo-legal jargon like it's going to change the outcome. The judge, however, isn't rattled for a second. Each time McLeod tries to derail the proceedings, the judge brings him right back to reality. As tensions rise, the judge eventually has no choice but to order him into custody for the night. The whole exchange is equal parts frustrating and fascinating. Watching someone cling to arguments that have no legal standing, only to be dismantled step by step. By the end, it's a clear example of how the system handles disorder in the courtroom. And it's a case that grabs your attention from the very first moment.
Will be representing himself.
Okay. I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or a 100 to 500 term. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
2. What really stands out here is the judge's composure. Despite repeated interruptions, he tries to give McLeod the benefit of the doubt, allowing him opportunities to speak and even attempting to explain the basics of legal procedure. It's a display of patience that most people would struggle to maintain, especially when dealing with someone who refuses to acknowledge even the most fundamental concepts of law. The judge could have snapped early on, but instead he methodically walks through each disruption. Watching this play out raises a real question. Is McLeod genuinely convinced of these ideas, or is he simply using the act as a strategy to avoid accountability? Drop your thoughts in the comments, because that's a debate worth having.
Okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble. Okay. Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or a $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
I don't understand the nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power, Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So, Mr. McLeod, do you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
1 second.
I can see why his attorney would Drew. Oh, shit.
Yeah, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh.
Prosecutor's office is generally allowed to attend, to observe. They participated. I'm removing them from the hearing.
3. At one point, there's a moment in the courtroom that feels almost too raw to believe. A comment is made, and you can practically feel the shared reaction of everyone present. It's absurd to the point of being comical. The judge keeps his composure, but you know that deep down, it must have taken effort not to react. McLeod, meanwhile, continues shuffling through a stack of papers like he's about to unveil a hidden legal loophole that will erase his problems. The scene is surreal, like watching a magician search for a trick that doesn't exist. His attorney's withdrawal suddenly makes perfect sense. Everyone else in the room can already see how this ends, yet McLeod pushes forward, convinced he's moments away from outsmarting the system. It's almost like watching someone play a game without knowing the rules, refusing to admit they're losing. That persistence is what makes sovereign citizen cases so bizarre and, at times, strangely captivating.
Mr. McLeod, do you understand the maximum penalty that you could face?
1 second. Okay, so in enforcement of your statutes, judges of all courts do not act judicially and are thus are not protected qualified by legal immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can you talk here?
I've challenged subject matter jurisdiction. Nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
jurisdiction doesn't
jurisdiction.
exist under the Constitution.
Your objection is noted. All right. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand.
4. By this stage, the judge has clearly had enough. What's striking is how he doesn't resort to anger. He simply responds with precision, cutting through McLeod's false arguments one by one. There's no theatrics here, just steady authority. The judge points out the flaws in McLeod's claims without raising his voice, making it clear that the law, not fabricated theories, sets the boundaries of the courtroom. It's almost a masterclass in control, professional, firm, and impossible to argue with. Watching this moment reminds you exactly why judges carry the final authority in proceedings like this.
Understand what's going on.
You can really tell the judge is just done with this guy's nonsense at this point. It's not even savage, it's just straight up facts. I mean, you've got this guy fumbling through papers, quoting made up laws, and the judge is just over here calmly roasting him in the most professional way possible. I mean, you gotta respect it though. He's calling it exactly how it is without even breaking a sweat here. Moments like this kind of just remind you why judges are the ultimate authority in the room here.
I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod,
the
stop.
court can be
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
I've challenged this court's jurisdiction. We haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcing the
Mr. McLeod,
statutes.
I have other man,
Clerk
Mr.
is
McLeod.
involved agency. What's that?
You know, I understand you want to object to things, and you're going to be allowed to object to things, okay?
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt, and you'll go back to a jail cell for a while.
Your
and then
Honor,
we'll leave.
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So
I
before I
cite-
can let you under,
I can
before I
cite
can,
laws. I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying enough to where I can comprehend it, as you say.
you know, comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong, and you can appeal.
There's no
to the
such thing as
Court
a
of Appeal.
statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So,
Mr. McLeod,
contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges. I
Mr.
understand.
McLeod is in contempt of court taken into custody.
Really? That's it. Protecting my rights is what it's all about. I'm sorry.
Fucking Joe.
This isn't true. You guys are following.
Follow unconstitutional
You're following
orders.
law orders. It's not
Not a
constitutional at all.
thing.
Mr. McLeod's in contempt, he's sentenced to 1 day. Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is about
notice.
the Constitution. I did nothing wrong except the question exercise my.
5. At the heart of it all, McLeod's performance is more embarrassing than anything else. He insists on representing himself, stumbling through papers and citing irrelevant lines, when he could have easily exercised his constitutional right to an attorney. Under the Sixth Amendment, he's entitled to legal counsel, even at no cost if he can't afford one. Instead, he's chosen to stand alone, treating the courtroom like a stage for theories that simply don't apply. The judge initially showed remarkable patience, slowing things down to give McLeod a chance. But even the calmest judges have limits, and eventually, the court had to shut down the nonsense. What makes this so striking is the confidence McLeod projects while undermining his own case. He's facing a serious felony charge, assaulting a police officer, which can carry years behind bars and long-term consequences, including losing basic civil rights. Yet instead of addressing the evidence or working toward a defense, he digs deeper into arguments that hold no weight in law. Courts have rejected these tactics for decades, and history shows they never succeed. Watching this unfold is both entertaining and troubling. Entertaining because of the sheer stubbornness on display, and troubling because of the real consequences waiting at the end. For McLeod, the outcome is inevitable: time behind bars and lasting damage to his future.